going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. Happy Tuesday. Happy Tuesday. All right. You guys want to watch some court? I want to watch some court. Let's watch some court. I've got two clips tonight. First one is I can't remember the name of the judge. It's out of Michigan. I know that. It's at a court that doesn't stream that often, but he had a good one today. It's the one on the thumbnail. It's a longer one. It's about 40 minutes. So we're gonna be watching that one for a while. And then the second clip I have is the latest installment of the fake attorney. It wasn't. You'll see it. We'll talk about it when it happens. But that there's that happened today as well. So we got both those tonight. Hopefully you guys enjoy them. You guys ready? Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
If you can have a seat there, please. We'll go on the record. This is People versus Richard Galt, file number 244943. The record should reflect Mr. Galt's presence here in the courtroom today. If I can have counsel put your appearances on.
Ryan Ziegler on behalf of the people.
I think Yana Ravi Gurmati on behalf of Mr. Galt.
All right, real quick. This is one of the courts that have their Zoom kind of set up funny. But the courtroom's in the top left. You can see. You can't see the defendant. He is sitting at the defense table. The defense attorney is standing up at the podium. But you can barely see the orange in the very bottom right-hand corner of the little square on the top left. But he is sitting at the defense table. You can still hear him clearly. You're just not going to see him.
We're here today. Mr. Gurmati has filed a motion to withdraw as Mr. Galt's attorney. I guess one thing that affects the court's consideration here, I want to make sure the record is clear. Again, because I think there's a difference between Mr. Galt, you asking the court to appoint a different attorney for you, and Mr. Gurmati asking to withdraw from the case. So I want to make sure that we're clear on the record which of those two I'm dealing with.
Well, I'm going to ask that I withdraw from the matter. I think the other issue, which, and I'll leave it to the court's discretion. Mr. Galt is requesting another counsel. There's a process to that because the court no longer appoints counsel. Mr. Galt has been made aware of that. Mr. Galt has been made aware of that by Mr. Thompson, who is the indigent defense counsel.
Actually, before we go further, Mr. Thompson is. Let me bring him in.
Okay, right. And I was just going to say Mr. Thompson wanted to attend this hearing as well.
Your Honor, I've filed several motions
Okay.
to the courts.
Okay, and we'll talk about that in just a second. Mr. Thompson, are you able to hear me okay?
I can hear you, thank you.
All right, we just got started with the hearing involving Mr. Galt. I asked for a clarification as to whether or not Mr. Galt was asking for different appointed counsel or whether Mr. Gurmati was asking to withdraw from the case, because those are two different considerations, or whether it's both. And so we've just begun that discussion just to bring you up to speed here. So Mr. Gurmati, you're asking to be withdrawn. Mr. Galt, are you asking for a different appointed counsel as well?
Yeah, well, Your Honor, first time I filed a motion, I was assigned, and this was back in July of 2024. I was assigned a new attorney because Mr. Gurmati was never actually. See, what happened is Mr. Seeger assigned himself to my case with a direct conflict of interest. He represented the victim in the case, the victim's boyfriend, the victim's sister, the victim's sister's boyfriend, both of the victim's children. And it took me 5 months, 150 days, before Mr. Seeger was willing to withdraw and acknowledge the conflict issue. So then, since there was a conflict issue, he handed me off to Mr. Thompson. Well, in the process, I got this letter here from Mr. Seeger says, I have enclosed the substitution of counsel. If you wish to have alternate counsel, this is your opportunity. And then again on this page, second page, I have enclosed the substitution of counsel. You may execute this form if you no longer wish me to be an attorney. You may. So this was with Michael Horwitz. I said, well, Mr. Seeger, Michael Horwitz, and you share an office, so it's still a conflict issue. So he goes, okay, well, I'll see what I can do. He goes, you have anybody else that you would be interested in? I'm like, well, I talked to Patrick Cherry. He said he'd take the case if you'll appoint him. Mr. Seeger talked to Patrick Cherry. Patrick Cherry said that he wanted $350 an hour. So Mr. Seeger said, well, we ain't paying that. Okay, whatever. So he comes to me and he's like, I talked to Mr. Guramuthi. He said he'd be willing to take your case. He goes, I'll send you substitution of counsel paperwork and you can sign and return to my office and we'll get Mr. Guramuthi appointed to your case. So he sent me the substitution of counsel paperwork, which I have a copy of here. I got the original back at the cell. I never got a chance to sign it. It's never been signed to send it to me. It's never been ordered by a judge that Mr. Guramuthi was even appointed to me as counsel. Okay, so I'm like, you know what? I'm not going to say nothing because if things go bad, I can always be like, Mr. Guramuthi was never actually legally appointed to my case. So that's automatic grounds for an appeal right there. So I didn't say nothing. Well, then Mr. Guramuthi refused to call any witnesses that I wanted him to call at the preliminary exam. So that's when I was like, you know what? Heck with this, I'm filing a motion to withdraw or filing a motion for substitution of attorney. So I filed a motion through Mr. Thompson because the case had to get handed to Crawford County because of the conflict issue out of Kalkaska. So I filed a motion and I was appointed a new attorney. Right here, for my August 1st, 6th court date is Shauna Sullivan. Right here, she's an insurance fraud investigative attorney out of Braintree, Massachusetts, that is allowed to practice law in Michigan. So I contact her and she's like, Mr. Galt, I'm not a criminal defense attorney. I'll contact the courts and get this straightened out. So she contacted the courts and I get a second notice for the same court date that says, this hearing will be held via Zoom. Defendant is lodged. Notice resent with no change other than defendant's attorney is now Guramuthi. So I got appointed a new attorney and reassigned Mr. Guramuthi. So then we go to the court date on August 6th, Your Honor, Zoom, and I'm in Wexford Jail. And you're like, okay, Mr. Guramuthi, how's 90 days sound for continuance to file motions? And Mr. Guramuthi says, your judge, how about 120 days? And you were like, will that be enough time? And he's like, absolutely. So then on December 3rd, 14 months after I was arrested, no motion's been filed. I'm going to use your exact words, Your Honor. Mr. Guramuthi, you didn't show up today to court. That is unacceptable. Mr. Guramuthi, you didn't file your motions today. That is unacceptable. That's unacceptable. That's ineffective assistance of counsel. 14 months later, that one motion's been filed on my behalf, and you granted him 120 days to file motions. I've never even got a copy of the motions that were filed. He gave me a rough draft of these motions that had my case and Joe Cunningham's case mixed together. He came to the jail 2 days before court, the court date where the motions were filed on time, to do the corrections. He's like, I'll get you the corrected copies that I'm going to file with courts. I've still never seen a copy of the motions that were filed. I don't know what copies of the motions were filed. So then I asked for transcripts, because I wanted transcripts, where you, Your Honor, stated, Mr. Guramuthi, you not showing up today is unacceptable. You not filing motions on time is unacceptable. I want them transcripts where you, Your Honor, said that, in case it comes to an appeal purpose. And then when we come to the motion hearing on January 24th, you're like, well, I'm not going to have you and Mr. Guramuthi both argue in motions. I said, all right, well, I'll let Mr. Guramuthi argue motions. So you're like, Mr. Guramuthi, do you have anything to say about arguing these motions? Mr. Guramuthi's like, no, Your Honor, I'm good. Well, if I'd have known he wasn't going to argue them, I would have argued them, Your Honor. You know what I'm saying? So there's another ineffective assistance of counsel. I've begged Guramuthi to filed several motions, and I've got a list of the motions here. I even researched case laws for him for his motions, and he refuses to file motions. He refuses to he refuses to request body cam footage of the search in its entirety. I want officer activity logs. I've got proof with me today of Detective Nichols perjuring himself on the stand under oath. I've got right here.
Well, let's try to stay on the lawyer issue, because that's.
Well, this is a lawyer issue. This is.
All right, I was trying to let him go as long as I could without pausing it. Oh man, the judge just let him ramble. So he's got a lot of issues. They haven't even got to his charges yet. They'll get to him. They're very serious charges, but all the issues that he's had in this case, and then now he's like hoarding. What? How do I call him? He's hoarding arguments so that he can appeal. Oh yeah, I'm gonna get an automatic do-over because of all this. Yeah, that's not something you want to say to the court, especially not to the judge. Just say to the lawyers out there, if you're an attorney and there's a procedural issue that you know about and you don't bring it to the court's decision or the court's attention, and then after everything's said and over with, you use that you knew about for months to appeal, could you get in trouble for that? Just asking. I know he's not an attorney. He's not held to the same standards as an attorney, especially when he's represented. But could you get in trouble for that?
Stuff I'm pursuing.
Well, I'm not going to make any decisions about what police officers did or didn't testify to today. So tell me how that relates to your attorney issue.
Because I've asked Mr. Grumusi to address this with Mr. Ziegler and be like, look, we could discredit your witnesses. We could work some kind of a deal, something. You know, I got my deal from Mr. Ziegler, Your Honor, was on 86 district paperwork with the wrong case number on it from the prosecutor. That was his deal. Another thing is I asked Mr. Grumusi to file a motion, is you know what, Your Honor, felony complaints, citations, anything signed in those are made under oath, sworn to. You got to be sworn to. I got a felony complaint right here with the paperwork filed from the prosecutor, signed with the complaining witness. It says I committed second-degree homicide on 10/30/2023 in Cold Springs Township. That's 2 days after the defendant was dead. I got a felony complaint right here that says the complaining witness has filed a sworn complaint in this court stating that on a date and location described above, contrary to the law, Mr. Galt, Cold Springs Township, committed second-degree homicide on 10/30/23, 2 days after the defendant was dead. I've asked Mr. Grumusi to file motions to quash charges due to the fact that I was illegally arrested, illegally arraigned on a felony complaint and a felony warrant that contains false information. It was never signed and dated by anybody, the return and tabulation, where I was arrested. I've requested the SIDNET reports, which is an electronic report record for arrest, to find out who even served the arrest record, because I never seen a felony warrant for 17 months. And I knew that the felony warrant was based off a felony complaint, which was inaccurate, and I couldn't do nothing without the actual felony warrant showing that I was illegally arraigned, illegally detained, and illegally arrested based on a complaint and a warrant with false information on it. Okay, this is where it gets good, Your Honor, and I brought this all to Mr. Grumusi's attention. The uniform law citation that was filed to go with the complaint, right here, case number, says nothing about second-degree homicide. In fact, the one that says second-degree homicide was filed on 11/4, 6 days after the defendant was dead, 4 days after I was arraigned, by Sloan Kowalewski, stating that I committed second-degree homicide on 10/27 at 12 o'clock p.m. It also says that I was arrested on a warrant on 10/30/2023. Warrants were issued until 11/1. That's false. That's lies in the Uniform Law Citation. Now, this is where it gets good, Your Honor. It says right here, do not
All right,
write.
I'm not gonna, this isn't I'm not making any decisions on that. I'm not gonna dismiss your case today.
I'm not saying you are, but I need this
You're
all
going
on
into
record.
argument here on underlying issues. We're just dealing with the lawyer thing. So you think he should have filed motions on these things?
These are issues that I have brought to Mr. Gramuti's
Okay.
attention, and he's failed to file any motions that I've requested. And I want it on record that these are the issues that I've requested the motions to be filed on.
Okay,
You know, these are major issues, Your Honor. They are. This is a murder case. There should be no topographical errors. There should be no misprints. There should be no false statements in felony complaints. There should be no false statements in warrants. Returns and tabulations should all be filed.
well, I don't know whether they're false or not. I don't know whether they're wrong or.
No, he's saying that the charges, like the charges for him aren't lined up with the dates on the reports. So there's something like that. I don't know. They're saying that he committed homicide on Wednesday, but in the coroner report they died on Monday. That's the kind of thing he's saying. So he's like, this doesn't make sense. This doesn't work. You can't say that I committed this act on Wednesday and then they died on Monday. That's what he's arguing. Which, I mean, that's an offense, but yeah, we'll see how it works out for him. Bold strategy. Phil, thank you so much for the 5 gifted memberships. I appreciate it, Phil. Thank you. Welcome to the 5 new members. And Terry with 5 more gifted memberships. Thanks, Terry. And welcome to the next set of 5 members. You guys are awesome. Thank you so much, guys.
Not, and I don't know whether that would make any difference. So, again, what we're here on today is the attorney.
So basically
You're asking for a different.
Basically, there's been breakdown in attorney-client relationship. Mr. Gramuti has filed a motion to withdraw. I filed a motion for substitution of counsel based on, and this is just a few of them, just a few of the things.
Yeah,
You
okay.
know?
All right, I understand what you're saying.
You know, just, I don't know what to do, Your Honor. I'm looking at life in prison,
Well,
and I got a counsel that refuses to file motions.
well, here's the thing, okay, and I'm gonna talk to Mr. Thompson, but one of the concerns I have is it's not gonna matter what attorney I appoint to you, because you're gonna find something wrong with any attorney
No,
that's
I'm not.
appointed to you.
No, no.
Well, because you think that certain things have some significance, and if your lawyer tells you legally you don't have an argument here, or legally these are mistakes, but they don't affect the validity of the charges, you don't agree with that, and so.
He spoke for about 5 seconds right at the beginning. He's about to come back in. You'll hear from him. He's trying to withdraw. So the attorney's trying to withdraw. The defendant is, trying to fire him. You can't fire a public defender, but he wants a new attorney. So they both don't want anything to do with each other. So that's why this case is kind of fun. And the guy's a little bit cray-cray.
So you're gonna be back here again with your next lawyer who refuses to file motions that the lawyer thinks aren't warranted. And you're gonna be telling me the same thing. You understand what I'm saying?
Yeah,
Like
but
you don't want to hear what your lawyer's saying because you disagree with it. And so you want me to keep appointing lawyers until you get one that agrees with you.
Well,
And that's not how this works. So that's my concern.
but don't, but.
When I listen to you talking, that's my concern is I could appoint 10 lawyers for you, and until one does what you want them to do, you're going to claim that they're not representing you effectively.
See, this is the
Because you're
thing.
not listening to what the lawyers are saying.
Mr. Garamusi doesn't even come and see me, Your Honor.
Okay, well, that's a different issue.
But this is the thing though, is the motions, Mr. Garamusi or whoever is appointed should be willing to file motions on these things.
Well, but that's
And
not
it's up to
true
you to
though.
rule on them, Your Honor.
Lawyers don't just file everything that their client wants them to file. They have an obligation under the law to only file things that have legal merit. So
And
if you want him to file something, and in his judgment as an attorney, he doesn't think that it has legal merit, he or any other attorney that I appoint for you isn't going to file it. And what I'm hearing you tell me is that you want an attorney that's going to do everything that you want to do. And that's not how it works. So that's my concern going forward with you and appointed counsel, is that, again, I could go through attorney after attorney after attorney, and we never make it to trial because you can't find one that's going to argue things for you that no attorney thinks has legal merit. So I'm just saying that for the record, that's my concern here. I do want to clear up some things that you said about the succession of attorneys and how we started and where we got. And Mr. Thompson,
Could I clarify before Mr.
Yes, Your
Thompson
Honor.
chimes in? Because I can just add a couple of things that Mr. Galt indicated. I think that's important for the record. So Mr. Seeger, I don't know the conversations Mr. Galt and Mr. Seeger had. But when I was.
Well, and I don't want to have you and Mr. Thompson, he's the administrator. I want to hear what Mr. Thompson says. I'll give you a chance,
Okay.
Mr. Gurmurthy. But
Thank you.
I want to hear what Mr. Thompson has to say is going to clear this up or shed some light. So Mr. Thompson, can you tell me what information you have as?
All right, and here's why Mr. Thompson's important in this. He is the one. He's one of the partners in his law firm, and I don't know when this happened. It's been since I've started my channel, but some jurisdictions in Michigan have taken the ability for the judge or the court to appoint a public defender, and they've actually assigned essentially a law firm to handle that whole process. So they've taken it away from the judge and given it to a law firm. This guy is a law firm that takes public defender cases. So that's why he's important in this case. I believe the defense attorney currently works for him. So that's where this guy comes into play. I believe. I think I got if I'm not right, I think I'm close on that at least.
The administrator of MIDC here.
Yes, Mr. Seeger contacted me. He indicated he was recusing himself from administering this case as well as being an attorney. I appointed Mr. Garamuthi, the court clerk. We've called and confirmed this with the court clerk. Made a typo on the P number, and that's how a lady named Miss Sullivan was identified on a court filing. But Mr. Garamuthi was appointed as attorney. Mr. Galt did request a new attorney through me. I turned him down. At one point, he did appeal. We had that administratively sent to Mr. Slough, the Otsego County Administrator, who issued a written decision also declining to appoint new counsel.
Okay, all right, thank you, Mr. Gurmurthy.
And that is where I was just getting at, Judge. So I don't know the conversations Mr. Galt and Mr. Seeger had. Mr. Seeger reached out to me about this matter as conflict for Kalkaska County. In those conversations, and Mr. Seeger may have had those conversations with Mr. Thompson previously or subsequently, I don't know. But one of the discussions was that since Mr. Seeger at the time was grieved by Mr. Galt, it made sense to not have Mr. Seeger on this case only administer the Kalkaska County MIDC administrative duties, and that should go to somebody else. And Mr. Thompson, being the Crawford County Administrator, only took over on this case to administer this matter. Whatever requests and funding or other things that we've had have gone through Mr. Thompson. At one point, I did reach out to Mr. Thompson with Mr. Galt's request for new counsel, because as Mr. Galt indicated, some of the motions that he wanted me to file, I think were frivolous. They weren't with what the law would require. And again, there was, when Mr. Galt indicates that a motion to quash was not filed, the court heard arguments that was filed. When Mr. Galt says that motions that he wanted were not filed, we did challenge the search warrant and filed motions to suppress evidence. Those were heard. We had arguments here in court. So I think Mr. Galt is incorrect that no motions were filed. The motions that he wants, that I don't believe legally would have any authority to be filed, were not filed because they're not there. For example, Mr. Galt wants me to file a motion to discredit Detective Nichols. I think that gets done at trial. There's no motion to discredit him prior to a trial. So again, the transcripts that Mr. Galt is requesting, he has those. because he has the preliminary exam transcripts. We had a full day, 8-hour preliminary exam in this court, and Mr. Galt was present. So again, some of the things that Mr. Galt indicates are not chronologically accurate. I did not know that there was that appeal process that went to Mr. Slough. I know Mr. Slough at some point did get involved because I received a subsequent letter from Mr. Slough because Mr. Galt had indicated that he wanted new counsel. I didn't know how Mr. Slough got involved, but I spoke with Mr. Slough and I indicated where my concerns were. But my breakdown comes in after all of those things were done, because suddenly Mr. Galt didn't get what he wanted. He didn't get a new counsel. He was turned down by 2 administrators. And I haven't met Mr. Galt in the last 2 weeks, maybe 3 weeks, because I'm not going to take his verbal abuse. I'm not going to sit there and get called derogatory names. I'm not going to deal with his threats. And if I'm going to spend my time meeting with him, it's got to be a productive meeting, not one where I get yelled at, screamed at, called names, and threats being made.
Your Honor.
So at this
I'm never
point,
yelled.
Second, I'll give you a chance. It's his turn.
I'm
I
sorry.
listen to you. Go ahead.
so when those things happen, I'm not going to waste time and get treated that way. I'm not going to subject myself to that. Mr. Galt is, and I've told this to him, he's not my friend, he's not a family member, he's not a relative, and I'm under no obligation to take his verbal abuse because he doesn't get things done the way he wants or wants, new counsel, whatever his beef is. At one point, he was upset regarding something that happened with his house in landlord-tenant court. Again, there's a limit for me being a punching bag. I've got to deal with this case. This is where I am. But when it gets over that line, I'm not going to deal with Mr. Galt's abuse that way. I'm not going to subject myself to that. I have some self-worth, and I'm going to hold myself to that. I've told Mr. Galt that, and Mr. Galt doesn't like that because I stand up to him. Leaving all of those things aside, Mr. Galt has filed a grievance. Mr. Galt has, my understanding, filed a grievance against Mr. Slough and Mr.
I
Thompson.
never filed one on Mr. Slough.
Mr. Mr. Galt's indicated he's filed a grievance against Mr. Ziegler. So in the middle of a murder trial and prepping, I have to deal with grievances that have strict time constraints and requirements and turning over documents and other things that come with the own separate proceedings that I believe are frivolous, but I have to deal with those. And I've just reached a point where I've had a breakdown with Mr. Galt. And then I can't do my duty. My loyalty to Mr. Galt is just diminishing because of his actions, his conducts. It's not something that I've done or I've not done for him. I've got kites from Mr. Galt that he indicates.
All right, that might be the comment of the night. You just made me laugh. Just aside, Mr. Patterson. You now have an attorney from Kansas. He'll take care of you. Thanks, Mr. Reeves. I appreciate that.
He doesn't have discovery. He's got 2 sets of discoveries, 10,000 pages or so of copies that have been made and provided to him. So when he says he doesn't have those, they're untrue. And I just can't do these things and then get into a position where I have to deal with grievances and malpractice suits when those are, again, frivolous, that he's claiming that he's filed and he's done those things. So I've reached a point with this breakdown. I will admit to the court, the only things that Mr. Galt does not have is the search warrant body cams, because I got them this morning from Mr. Ziegler. They're in my pocket. And again, certainly my intent is to download them to my office drive, so I have a copy. There's a laptop at the jail, and then Mr. Galt will have a copy to watch those there. So that's the only thing that he doesn't have, but he doesn't have those because we didn't have them until this morning when Mr. Ziegler handed them to me in court. Outside of that, I've had numerous emails with Mr. Ziegler, numerous phone calls. We've talked about a lot of other issues, litigating issues. At one point, Mr. Galt wanted me to set up some interview with the FBI. And in fact, made threats because I was not doing that, made threats towards me for not setting up the interview. And again, I indicated to Mr. Galt, I need to know what you're going to tell the FBI because you have certain rights. If you're going to incriminate yourself, I have to advise you and warn you of those rights. He wouldn't tell me. We did set up the interview. The interview was recorded. And again, Mr. Galt, that interview never went anywhere because Mr. Galt got angry and upset because it was being recorded. The FBI agent did Mirandize Mr. Galt, and
Yeah, and they actually set up an appointment and an interview with the FBI. This is crazy. This case is crazy. And I I say this. I've said this before about defendants, but I feel like he's the kind of defendant that would turn quickly to be a sovereign citizen. If he didn't have an attorney that stopped him from filing his meritless motions, yeah, I feel bad for the attorney. Now he filed a grievance against him. I've seen other judges instantly remove an attorney from the case when that happens. Um, yeah, we haven't heard from the prosecutor yet. The prosecutor is about to come in and he's about to complain too.
That's not how Mr. Galt wanted to operate. So all of the things that Mr. Galt has done has, at least for me as an attorney at this point, led to a breakdown where I can't communicate with him. I can't represent his interest. And I refuse to go forward with this case and assist Mr. Galt any further because of what he's done with his verbal abuse, his threats, his derogatory attitude towards me. And I'm just refusing to put up with that, Judge.
Mayor!
All right, Mr. Ziegler, do people take any position?
Your Honor, normally I would leave this kind of thing to the court and to the attorneys, but in this case, this is a case that has been going on for quite some time. Obviously, it's a very serious case. It's a case I would like to get to trial as quickly as possible. I agree with the court's concerns regarding Mr. Galt's behavior. I think it doesn't matter how many attorneys you appoint, and that's evident from the fact that Mr. Seeger had to withdraw, and Mr. Galt grieved him. Now Mr. Gurmurthy is asking to withdraw, and apparently Mr. Galt is grieving him. I have no doubt that if you appoint a new attorney to represent Mr. Galt, that attorney will ask to withdraw. Mr. Galt will grieve him, and we can play this game for however long as Mr. Galt wants to play it, or however long as the court wants to entertain it. But at the end of the day, we're going to have a trial on this case. There's no likelihood of any sort of plea resolution. We have a trial set in May. I would prefer to have that trial as opposed to appoint a new attorney, kick the case out 6 months, and then come back here in 6 months on probably similar issues where that attorney is not going to want to file frivolous motions. And Mr. Galt wants that attorney to file. So for those reasons, Your Honor, I don't think the court has to permit Mr. Gurmurthy to withdraw. I'm certainly sympathetic to Mr. Gurmurthy's position here today. I think he had to do what he had to do. He had to file this motion. He had to make his conflicts known to the court. I certainly wouldn't want to be in his position today, Your Honor, but from my perspective, I have a duty to the victims to bring this case to a trial and to a resolution as quickly as possible, and I would oppose any further delays.
Mr. Galt?
All right, that was a little low. I should have turned the volume of that when I was editing the video. But so for those of you that couldn't hear, the prosecutor he pretty much said, hey, listen, this is the third attorney. If you let him withdraw, he's going to be assigned another attorney. We're going to have to kick the can down the road to push the trial off again. And the same thing is going to happen. So it sucks, but we need to move forward. This is getting ridiculous. And, that's kind of the resolution to a lot of the sovereign citizen cases we see that get rid of their attorneys all the time. The court's just going to make the decision. And one of the public defenders just had to bite the bullet and do it. But yeah, this is going to be insanely difficult to represent him when you can tell they don't get along at all.
Anything else?
Your Honor, I've never verbally abused Mr. Gurmurthy. We've had conflicts. Yes, we have. We've argued. Yes, we have. But the things that I've asked Mr. Gurmurthy to file motions on are legitimate things. The fact that I never even got a copy of the motions that he filed is legitimate. Your Honor, you're the one that told him this is unacceptable. You didn't show up to court. This is unacceptable. You did not file your motions on time. That was 14 months. Mr. Seeger killed 5 months before he was willing to withdraw because of the conflict issue. I didn't grieve Mr. Seeger for another 6 months after that. So it's not why, the grievance is not why it got handed over to Mr. Thompson. The grievance didn't come for months, 6 months after Mr. Gurmurthy was assigned the case. Okay, I mean, I got a search warrant right here that was never signed by a prosecuting official, by a non-attorney magistrate. Mr. Giramuthi fails to be willing to file a motion on these things. Your Honor, you said in court last time we were here that you're not gonna have this come back on an appeal. Your own words, Your Honor. So these things are things that are gonna make this come back on an appeal. Mr. Giramuthi just got a copy of the body cam footage of the search today, 18 months, Your Honor. And he just got it today. I've been requesting it the whole time. I've been requesting officer activity logs the whole time pertaining to the activation, deactivation of body cam footage. I've researched case laws. I mean, all these things are legitimate motions that should be filed, Your Honor, and you, Your Honor, get to rule on them whether they're frivolous or not. That is your job. These are legitimate things that counsel should be filing motions on. As a defense counsel, he works for the state. You know he works for the state. He don't work for me. You know, he's told me several times, I got funding for this, I got funding for that, I got funding for the transcript. I contacted Nicole Hagstrom, the transcriber. She said, I contacted Mr. Giramuthi. He said he'd do what he has to do on his end. We'll get you them transcripts. Nothing. I got a paper right here signed from Mr. Paul Stout. Said that appointment of substitution of counsel is warranted only by showing of good cause. Good cause may exist when a legitimate difference.
I understand that. I don't need you to read that to me. I know what the standard is.
And it stands right here, Paul Stout. Mr. Giramuthi's filed a motion, said there's been a breakdown in the client, destruction of communication and breakdown in the current attorney-client relationship. I filed several motions. There's been a breakdown in attorney-client relationship beyond repair. Beyond repair. If you send me to trial with Mr. Giramuthi, Your Honor, that's automatic grounds for an appeal. You said yourself, you don't want this case to come back on an appeal, and I'm quoting your words over and over again. If you don't want it to come back on an appeal, sign me a counsel that's gonna file these legitimate motions.
Okay, all right, you're just starting to say the same things over and over again.
You know, I'm not trying to waste the court's time. I just want proper representation.
Okay, I understand.
And then, I'm sorry, and the typo.
He's not trying to waste the court's time. He just said he's been in jail for 18 months. This is his third attorney. They haven't been to trial yet. I'm going to say that there's one common denominator, maybe two, maybe the judge. Yeah, I guess could be the prosecutor, maybe. But you gotta look in the mirror at some point, dude. You got to. If you're not getting along with anybody, chances are it's you, man. Chances are it's you.
Mr. Thompson says typo. Your Honor, this is a murder case. There should be not typos. The T should be crossed, the I should be dotted. There should not be wrong dates, wrong addresses. None of it. This is a murder case, Mr. Ziegler. It's a murder case. This stuff should all be checked and double checked and triple checked and quadruple checked before it is even filed. The notice right here, let me show you this, Your Honor, before we end it.
Okay, I don't disagree with him on that part. But it's a P number. It's probably very easy to transpose two numbers, and that's what happened. And they caught it really quickly, and they fixed it. Yeah, that's not grounds to appeal, though. I mean, I'm sure that happens. It's what happens when you have a 5-number system. Sorry, man. Still not going to work.
Right here, Mr. Giramuthi withdraw is dated December 9th. December 9th, dating where is it? I got it right here, Your Honor. I'll pull it out of this one. The notice for hearing for today, dated December 9th, 2024, for an April 8th, 2025 court date. That's 4 months ago. This paper right here is grounds for an appeal. Mr. Seeger, 150 days. Here's another 4 months. Mr. Giramuthi didn't represent me. That's 9 months out of the 18, Your Honor. My 180-day rule was violated. My right to a speedy trial was violated just because of these issues. Mr. Ziegler in his motions are quoting COVID-19 case laws. for violating my 180-day rule and my right to a speedy trial. You read the motions, Your Honor. I've actually got them right here if you want to go through them again. His motions are quoting COVID-19 case laws for violating my 180-day rule and my right to a speedy trial. There's grounds for appeal. Any case is prolonged for more than 18 months. The people's got to answer for it. By the time I go to court in May, it's going to be 19 months. That's automatic grounds for an appeal. The people are going to have to answer why I wasn't in trial before 18 months.
You keep firing your attorneys. It's on you. You're not going to win that. The people don't have to answer for that. The prosecutor just said, I don't know, 15 minutes ago, sorry, Mr. I'm going to butcher his name, Guthrie. I'm not even going to try. The defense attorney. It's like, I'm sorry. I really feel bad for you in your position. But I'm going to object. No, I'm not going to let you do. I'm not going to let you withdraw. I mean, he that's his opinion. It's obvious. It's up to the judge. But yeah, this is taking too long. The prosecutor already said it, but it's being charged to the defense, not the state.
Okay.
You know what I mean? I mean, I'm trying to save the court's time, Your Honor. I just want
I
proper
appreciate that.
representation.
Yeah, okay, all right. First of all, with regard to allowing counsel to withdraw or appointing new counsel, this matters within the discretion of the court. I'm acting within my discretion in ruling on this. First thing I would say, Mr. Galt, is you're free to hire your own attorney at any time that you want. Nobody's forcing you to have court-appointed counsel. So you're free to hire your own attorney. To the extent that you're asking the court to appoint counsel at public expense, there's a process for that. And that process has been followed. And it's resulted in Mr. Gurmurthy being appointed as your attorney. The fact that you filed grievances against him or other attorneys isn't a reason for the court to appoint new counsel. It's not a reason for the court to allow counsel to withdraw. That's been through case law clearly established that defendants are not allowed to delay cases or shop for new attorneys by filing grievances in the hopes of having that attorney disqualified or somehow being required to withdraw. So the grievances aren't a reason. MIDC has addressed your request for new counsel. Under the law, it's clear that the court is to be minimally involved, if at all, in that process. This is the last step, which is the only reason why it's before me, but it's clear that the legislature has determined that the best process is for the court not to be involved because the court's supposed to be impartial and shouldn't be involved in issues relating to your counsel. So this is only here as a last resort, but MIDC has followed their policy and procedures and they've denied you from receiving new counsel. So the MIDC, through two different administrators, have determined that there isn't good cause for you to be appointed new counsel. I have concerns, as I articulated before, and listening to you, but it just reinforces those concerns that it doesn't matter who's appointed to you as your counsel. I'm convinced that you're undertaking a course of conduct here to create appealable issues on your own, and you've admitted it. You're on the record. You told me that you purposely didn't say anything about paperwork that you received and let counsel go forward in the hopes that that's going to create an appealable issue. So I think you're actively, and I want the record to reflect that I think you're actively trying to do things here as part of the pretrial process in hopes of creating appealable issues so that if you are eventually convicted, you'll have a basis to come back. And I think that's important because to the extent that I would find good cause to appoint you different counsel or to have Mr. Gurmurthy withdraw, I think you continue along the same course of conduct with the new attorney. Not only to delay as long as you could in the hopes of getting to the 180-day issue or whatever you perceive to be as issues that could result in a reversal of your conviction later, including delay, including complaining about your counsel, including doing things in your interactions with your counsel. All of that, I'm convinced is a deliberate course of conduct on your part aimed at creating appealable issues. And I'm not going to allow you to just continue to do that over and over. I think there is not cause here to appoint new counsel because, again, I think the same issue would simply come up over and over again. We did have hearings on the motions that Mr. Gurmurthy felt had legal merit. I agreed that they had legal merit, and I made rulings on those issues, a lot of which involved issues that you're raising here today about affidavits and signatures and those types of things that the court has addressed.
But how
And
about,
not every mistake, not every typo means that the court has to throw out an entire case against you. So the fact that there are errors, there are minute typographical errors in every case, I would argue. But that doesn't mean that you're just entitled to dismissal of charges because an I didn't get dotted or a T didn't get crossed. So to the extent that you think that's an appealable issue or a reason for your counsel to file a motion to dismiss murder charges against you, which are very serious, I just think you're wrong about that.
I'm not saying that.
You did say that, and I'm not going to debate. Yeah, I listened to you. I was very quiet. I let you say everything that you wanted to say. Now it's my turn. If you're going to keep interrupting me,
Sorry.
I'm going to have you removed from the courtroom, and I'm going to continue to make my record.
I appreciate the judge putting his foot down. He should have done a lot sooner, though. But he's right. He let him say everything he wanted to. And yeah, it's no longer your turn to talk, my dude. I don't know why I called him my dude. Take that back. I need to take that back right now.
Again, I don't think there's good cause because I don't think this is a legitimate disagreement between you and counsel. I don't think I don't think you're raising legitimate points. I think this is, again, a strategy on your part to try to delay the trial, to create an appealable issue in and of itself, or to create problems with counsel, to create appealable issues. And I'm convinced that, again, to the extent that I would appoint new counsel, we'd be back here in 3 months with the exact same issues. I think Mr. Gurmurthy filed motions on the things that he felt had arguable legal merit. The court made rulings on those motions. So the court is going to deny your request for appointment of new counsel. In terms of Mr. Gurmurthy, your motion to withdraw, I agree with Mr. Ziegler's sentiments that you're not in an enviable position. It's a difficult position to be in. I agree that you don't have to put up with abuse. Mr. Galt, to the extent that you're going to argue with, verbally abuse your lawyer, you're only hurting your own case. And so I would suggest to you, you've got a trial date coming up in May. I would suggest to you that it's in your own best interest to start cooperating with Mr. Gurmurthy and start working with him instead of working against him. But that's up to you. You're going to make that decision. We're going to go forward with trial in May as scheduled. Mr. Gurmurthy, the court's denying your motion to withdraw for the same reasons that I'm not allowing new appointed counsel. And the only thing I would say, Mr. Gurmurthy, is to the extent that Mr. Galt doesn't want to cooperate with you, to the extent that he engages in abusive verbally conduct with you, arguing with you, he's only doing that at his own risk. And again, I'm sorry that you're in that position, but I think that's where we're at. So, and Mr. Galt falls in your court as to whether or not you want to work with your attorney. But we're going to proceed with trial as scheduled in May. And Mr. Gurmurthy, I just request that you prepare an order that reflects the court's ruling today. Submit that under the 7-day rule.
I was just going to send it to Mr. Ziegler for approval and we'll submit it. Normally we're good with communicating that. So we just do that.
That's fine.
Your Honor.
Yep.
Does it matter that this was never, his appointment was never consented by me, never ordered by a judge?
I guess that's something you can bring up on appeal if you're.
Okay. And the fact that Mr. Gurmurthy has admitted that there's attorney-client breakdown beyond repair?
I don't know that he's done that.
He did. It's in his motion.
That's, again, you want to create appealable issues, so you can bring them up on appeal if you're convicted.
Okay.
All right.
Okay.
All right. I feel like that one dragged on. It was interesting. I told you it was interesting. I am happy for the defendant for one reason. After he didn't get his ruling, he didn't say, "Okay, well, I'm just going to represent myself." That's usually what people go with when they're like, "Oh, you're not. I'm not letting this guy get anywhere near me. I'm going to represent myself." He was at least smart enough not to do that. Okay. Next case. Oh yeah, this is the fake attorney. I told you. I didn't actually watch this. I was listening to it while I was doing a little cleaning this afternoon. It was kind of more this afternoon. I feel like it was right before lunch. And it's yeah, I was kind of listening to it, but I was like, all right, I'm just gonna throw this on my live tonight because I've covered her first 3 hearings. I feel like this one was a little bit boring. Not gonna lie, but I got to do the follow up, and I think this is it. I feel like Judge Simpson makes a ruling. I do remember that, so this might be the last time we see her. Well, she starts a case in front of Judge Washington. Is that tomorrow? She has an attorney over that one though, so it's not as. Yeah, that's tomorrow. She's in front of Judge Washington tomorrow. Okay, I got a lot on the calendar for tomorrow, guys. I got a lot. All right, fake attorney. Let's go.
Okay, court does call the case. R&J Group Holdings versus Staffeld. I think it's Staffeld.
Yes, Sparkle.
Appearing on behalf of R&J Holdings, Lane.
Good morning, Your Honor. This is Dr. Rosada Stafford on behalf of myself.
All right. Have the parties tried to talk at all or no? Are we going to go to trial?
No, there's no talking, unfortunately. I'd be willing if the court would direct us to, but I don't think there's anything we can discuss. This is a termination of tenancy case. Talk about it.
Your Honor, I'm open to talks, and the communication is not a good strategy, but this is not a tenancy termination. This is a purchase agreement, the subsequent tenancy will be signed as Exhibit G with this gentleman's client, and it's dated November 17 of 2024. Signed the purchase agreement that we want this to be enforced, as a matter of fact.
Yeah, but I can't enforce the purchase agreement. You've been to other courts to enforce that purchase agreement, correct? Then what was the complaint in federal court?
Court case, Your Honor, is a wrongful foreclosure suit against Wells Fargo that subsequently we added and amended the complaint and added R&J to that case. That's why.
And then that case, did he give you?
Yeah, I just need contact information and then call back. He could see me anytime today.
Ah, wonderful. Hold on. Where did Mr. Chavez go? I'm going to break in this case, recall Evergreen versus Chavez. I need you. What do we need? I need
contact information for Mr. Chavez and then just some general information about
the dog. Oh. And then they can see you.
They can see me when you're done.
No, once that happens.
I will call back the Humane Society and they could see them sometime this afternoon, tomorrow, depending on your availability. They'll make it happen.
Oh, it could be today because he got somebody with him. So, okay. So we'll get that information. She'll come out, get that information from you. I'll adjourn this matter out to my next date, which is April 22nd, 2025 at 9 a.m. Okay? Yes.
All right. Yeah, I didn't edit this part out, guys. Sorry. I forgot this happened. This is just really quick to get a couple people out. It was the case before this one. and it had to do with an emotional support animal. It was interesting. It was kind of funny. Yeah, I actually might throw that in my live tomorrow night because yeah, it was interesting.
Thing I would say is if potentially Mr. Chavez's caseworker could maybe help him apply for mental assistance in the meantime as well. Yes.
Yeah, I think they were working on that piece also, but we weren't going to get anywhere until the dog got his shots.
Yeah.
So, okay. All right, great. All right, so get all of that and then we'll.
She has she's a doctor. She's a doctor attorney, a doctor lawyer. So she's just rolling in the money. That's why. That's how she can do it.
And do you have copies of the previous? Make sure to have with him a copy of the previous vet records to take with him down there. Okay, so that, all right, we'll get it taken care of today. Thank you, folks. All right, we're back on.
No, there's only one Dr. Judge, and that guy lives in Vegas, and he's selling vitamins so we don't die from the COVID vaccine. Oh man, I keep forgetting to try to get in touch with that guy. I need that vitamin because I'm in jeopardy. What did he say? If you got both, oh man, trying to make me remember things. I don't remember the kind of shots. I'm just gonna keep playing. I have no idea what I'm trying to remember anymore.
The R&J Group Holdings.
I only half listen to you, but don't worry. I only half listen to everybody. It's the only thing I can do.
All right, the question.
No, it was Pfizer. Pfizer. If you took if you got vaccinated and you got both Pfizer shots, then you're gonna die this year unless you take the vitamin that Dr. Judge is selling. That's what it was. Yeah, and I both my vaccinations were Pfizer, so I need to find this vitamin.
You added R&J to the federal case, correct?
Correct.
And then that case was.
That's not true. Don't do that. Don't make me feel bad. I don't. It's not intentional. I see you in the chat. So hi, madam. Hi.
Dismissed.
It was not.
Okay. Is it pending?
Yes.
And did you get a stay of these proceedings in federal court?
I didn't petition for a stay in federal court. I'm petitioning to this court for a stay. Right?
That stay is denied. I'm not issuing a stay. So, ma'am, I'm trying to figure out what's your claim, because I read through everything that you filed before the court, much of it which was also stricken, but then you filed other things. You haven't complied with that. As to the issue of possession, I don't see that there's an issue for me to try.
Issue of possession is a non-issue. First of all, according to the lease, the court that has jurisdiction, we agreed on that, is the Circuit Court of Oakland County on Section 13 of the lease. Excuse me.
I don't think you can't confer jurisdiction that way.
Well, they have
what?
They have put in that lease agreement that in case of conflict, we have to go to Oakland County Circuit Court.
Yes, but the property resides in Washington.
Correct, I agree with you.
Then venue and jurisdiction is here.
Correct.
Hey, you can't do it that way. Even if.
All right, I for the people that didn't didn't get the reference of what I said, I probably should just let you know. There was a defendant that said she needed to be let out of jail because she had a new career opportunity working for a doctor judge selling vitamins for people that got their Pfizer vaccines. That's where that joke came from. I probably should say that. I don't believe it. It's not something that I'm trying to sell you guys. So just letting you know.
Even if that was agreed to, it's unenforceable.
I agree.
Okay, so we're here. So everybody doesn't have to head to Oakland County. It might make my day easier if you would, but you can't. Okay, so it's here. And so when I look at everything, I don't see as to these two parties that there's anything for me to try, that they're entitled to possession of the premises.
Despite the purchase agreement they signed?
The purchase agreement, you're making that part of, did you file an action in circuit court regarding the purchase agreement?
I'm intending to do that.
But you haven't. And they're saying you defaulted on the purchase agreement.
You're wrong.
Okay. But if you're seeking to enforce the purchase of the property, can't do that here.
The lease agreement has a provision that within a year we are entitled to purchase the property. That's what we're trying to do. To buy the property.
Have you purchased it?
We secured the loan. We ordered the title work. The title work shows that there is a lien on the property and the mortgage company would not issue any loans to me unless the lien is removed by Mr. Molina's client.
Sir, what's your position on this?
That's simply not true, Your Honor. There were two liens on the property. One of them was a mortgage lien that's paid at closing.
Right.
Proceeds of the sale. The other was a lien that was placed on the property by the home.
Yeah, Mr. Beeps. Like I said, this is the least interesting and exciting hearing of hers. It's just the last. I think it's the last one. I'm pretty sure we get a ruling at the end of this. Pretty sure. Yeah. While on pause, MB. Yep. Pushing vitamins. Yeah, daily vitamins. Take them. Take them. Take your supplements if you need them. No, man. Oh, man. Thanks, MB.
Homeowners Association, by virtue of her actions while she was in the property before. That aside, we did obtain title commitment, guaranteeing her clear title at the closing. And I've got documentation and we submitted that to her mortgage agent and her prior to the date the closing had to occur. So that's simply not a true statement.
And the closing hasn't occurred.
No.
We submitted the documents that they gave us to our mortgage person and to the title company, and neither one of them accepted.
Now, there are upsides to HOAs. There are. HOA Karens should be kicked out. That's who should be kicked out. Like some HOAs are actually, they're not terrible. But yeah, they get a bad name because, yeah, a lot of them are bad.
Let me ask you this. Are you going to let her buy the property or do you want it back?
Today we want it back. If she wants to negotiate or buy it later, that's fine with us. We're not opposed to her having the property. What we're opposed to is her staying in it for free subsequent to the chronological termination of the lease. So my client does want it back, and I'm not sure at this point whether he wants to sell it to her, but I shouldn't say that he does. But there's nothing personal here. We just want it back. because we're entitled legally to it. And there was no breach on our side of the purchase agreement, period, in our opinion. I have documentation.
No, I looked at everything. I don't see any breach regarding the purchase agreement. It's just,
Yes, there is, Your Honor. May I speak?
well, why haven't you brought an action for the breach of the purchase agreement?
Because they brought an action for possession. I'm busy responding to that.
This is a landlord-tenant case. They're trying to get it's a notice to quit. They want to kick her out of the place, or notice they want to get possession back. She owned the house, or she had a mortgage. She defaulted on the mortgage. There was a foreclosure sale. Whoever bought it, they had a repurchase agreement with her, and either she defaulted on it or something happened. But so she came into court saying, I have a repurchase agreement. They can't take possession back of this place. And that's what the legal argument is. So that's why yeah, I'm not gonna say anything else. I don't want to spoil anything. I think I was about to spoil the ending. But that's what's going on. They're just trying to get possession of it. I think it's just I think it's a house.
Go ahead. What do you want to say? What do you want to say?
I'm sorry.
What do you want to say?
What I want to say is the gentleman's statement is absolutely incorrect. We have paid money to run the title, and since they purchased the property, they are the violator of the lease agreement because they were not supposed to get a mortgage on this property. They have. Also, there is a fee on the property that prevents us from going forward with the purchase of the property because of the lien. And the lien is not removed. And it happened when they own the property, not we own the property.
The lease has expired.
The lease has expired, but
but hold on, ma'am. The lease has expired. You're seeking to enforce this purchase agreement.
Correct.
That's not done here. That's why I'm saying I don't have a tribal issue. The lease has expired. They filed proper notice. They're entitled to possession of the premises. If you wish then to enforce your rights regarding that purchase agreement, that's going to have to be filed in another court.
Okay.
I mean, I think it's as simple as that. Is there anything else you want to tell me?
So I'm here today fighting for my, this is my primary residence. They promised they're gonna sell it to me. They are backing up from their promise. They broke every single provision in that.
Okay, ma'am, you can tell me that all day and night long.
That's fine.
And the problem is that has to be heard someplace else. It can't be heard here because the lease expired. They're seeking possession of the premises. So court after hearings finding no tribal issue, granted judgment for possession to the plaintiff. There is no redemption amount per se. What I will do, ma'am, is normally a writ would issue in 10 days, but you can I'll indicate that a writ may.
Someone actually, I mean, I didn't confirm this, and I don't remember if it was on Discord, if it was the last time I covered her, but somebody said where she's from and where she went to law school. I don't remember where it was, and I don't want to guess. I don't want to be that person, but somebody did look it up, and yeah, again, I didn't confirm it. I accepted it as true. Could have just been a random guess. I don't know, but I don't remember. If whoever did it, if you're in the chat, say it again, please.
Issue April 30th. Then if you wish to file some action or seek a stay, you can do whatever you want to do, but I'm gonna have a red issue April 30th.
Also, I put a $5,000 in escrow, and that be released
To whom?
to myself.
That's exactly what it was, Sparkle. She's not from the U.S. And yeah, again, I don't want to guess on what country it was. I don't know why I have Poland in my head, but it was like, I don't think that's it. I don't think that's it, but that's what I'm remembering. But my memory kind of sucks.
If I may briefly.
You could say, go ahead.
Rent is due prior to the end of the termination of the lease, so we're not accepting any rent for periods of after the expiration. So I believe my client's entitled to that.
I beg the difference, Your Honor. They are saying that lease was terminated as of November 1st, and I paid them October payment. So as of November 1st, they are not entitled. If they claim this lease is void and null. Excuse me.
You guys done? 'Cause here's what I'm gonna do. I'm gonna issue the judgment.
Okay.
Okay? Red date of April 30th. I'll set a hearing on the release of escrow for May 20th, 2025, after I see where the landscape is. All right?
Thank you, Your Honor.
Same
God
10-day
bless you,
appeal
Your Honor.
period. Same 10-day appeal period in the.
On the judgment, you mean? Yes. Correct.
Thank you.
Thank you.
I'll prepare to submit it to you.
All right. Thank you, sir. You guys do the same. Thank you.
All right. That's it. May 20th. I didn't have that written down. I told you I was barely listening to this afternoon because it wasn't interesting. I felt like I had to play it though to put the cap on it. But we're gonna get one more hearing. Sorry, I'm just jotting my notes down real quick. Okay. All right. Show's over. Time to go home. Thank you guys so much for watching. I do appreciate it. And before I miss a super chat, Sparkle Poots. Thank you so much for the super chat. Just cause I can, and you're pretty worthy. Thanks, Sparkle. I appreciate it. All right. Yeah, I mean it's still good. It's still good. I think I've just kind of zoned out from court today. I watched a lot of court today. Got a lot of content, and but there were a lot of hearings like the first clip, just really long ones. Usually, I like the shorter ones better. I don't know. I just like jumping around. But I watched a lot of long hearings today, so I think I'm just kind of at my court capacity for the night. So yeah. Anyways, who we're gonna raid? Well, we'll do Katie Z tonight. We'll go to Katie Z. All right, had to make sure I hit that save button. I'm not gonna make that mistake again for at least a couple more days. All right. You guys are awesome. Thank you so much for hanging out with me. I do appreciate it. Like I said earlier, I've got five defendants on my calendar for tomorrow. It's gonna be a busy day tomorrow. I don't think I have any true soft sits, but I've got a lot of soft sit question marks, or what I call soft sits. So I got a couple of those tomorrow. All right. Yeah, you guys are awesome. Go tell Katie Z I said hello, and I will see you tomorrow. Okay. What, Wixon? Katie Z is doing a live stream. Okay, yeah. Yep, we're going to Katie Z. All right, you guys are awesome. I'll see you tomorrow. Until next time, bye.